Well, good afternoon, everyone. Thank you for joining us. My name is Jane Sanchez, and I have the privilege and honor of serving as the Deputy Librarian of Congress for Collections and Services and the 25th Law Librarian of Congress. Each year, the Law Library commemorates Human Rights Day with a special program to promote understanding and recognition of a critical social, economic, or cultural human rights issue. In previous years, the Law Library has hosted a number of Human Rights Day events that highlight various aspects of this topic, such as impact of the women's suffrage movement, repatriating Native American cultural property and remains, human rights in Eastern Europe, Islamic law reform, rights of refugees and internally displaced persons, among others. This year, Human Rights Day theme relates to the COVID-19 pandemic and focuses on the need to build back better by ensuring human rights are central to recovery efforts. In the spirit of today's theme, with coronavirus pandemic changing our lives in ways that no one could have predicted and imagined, we've decided to dedicate our panel discussion to contact tracing and the right of privacy. Our respected panelists, Associate Professor at the University of Minnesota Law School, Alan Rozenshtein, NASA's Associate Chief Information Officer for Transformation and Data and Chief Data Officer Ronald Thompson, and the Law Library of Congress's Senior Foreign Law Specialist, Jenny Gesley, will discuss privacy concerns with COVID-19 contact tracing. Alan, Ron, and Jenny, welcome and thank you for being with us today. Now it is my pleasure to yield the virtual floor to our panel moderator, Assistant Law Librarian of Congress for Legal Research, Mr. Peter Roudik. Take it away, Peter.
Thank you, Jane, for your introduction, and thank you, everybody, for joining us today in celebrating this Human Rights Day. Facing an incredible public health and public safety crisis, we decided to discuss how to preserve our security without sacrificing civil liberties, and what challenges for human rights are posed by increased public safety measures. Having the 9/11 experience, where enhanced security measures didn't go anywhere after almost 20 years, we understand that increased digital surveillance will likely be our future because this is an effective tool to fight infections. That is why we are talking today about contact tracing, which is commonly viewed as an important instrument needed to avoid the spread of the virus. We are going to assess different approaches undertaken to implement and regulate this measure, and I would like to thank our speakers for sharing their expertise with us. My first question is to Professor Rozenshtein. Monitoring of quarantine and isolation regimes and even the contact tracing are not new measures aimed at fighting infectious diseases. However, never before these forms of monitoring were automated to such degree as during this pandemic. In your writings, you say that digital disease surveillance is becoming a required element of a public health system. But is this surveillance sound from the constitutional law perspective? Are there legal mechanisms in place to protect one's personal information and defend individuals from unreasonable intrusions? What needs to be done to ensure privacy protection and the legality of tracing patients? Please.
Well, first, Peter, thank you so much for having me. I really appreciate the opportunity, and thanks for everyone for joining this discussion. So let me say a few things in response to your question. First, I am not an epidemiologist, and I don't even try to pretend to be one on the internet. The expertise that goes into figuring out how to effectively fight a pandemic like COVID is something that I respect enormously and try not to opine on. To me, the question of whether or not automated tools are necessary to fight COVID or fight future pandemics, that's really up to the epidemiologists to tell me, right? Now, looking at the example of other countries, it does seem to me that they can be a useful tool. One thing I will say is they have not been used particularly effectively in the United States for a variety of reasons that we can get into. But in the United States, despite having a couple of states here and there trying to use some of these tools, there hasn't really been a mass deployment of them. I mean, especially as the virus has continued to spread, and as at this point we have essentially a nationwide community transmission problem, the window for using automated digital contact tracing tools has likely at this point closed. Now, hopefully, once we get to the spring, we'll have a vaccine, and so we'll be able to bring this pandemic under control fairly rapidly. The reason I mention this is because I think the analysis of the legality or the policy implications of digital disease surveillance is most relevant for the future, for the next pandemic. Hopefully will not be anytime soon, but given our interconnected world, we should, as they say, plan for the worst and hope for the best. So with that said, let me just spend a moment or two talking about the legal issues. So there are a lot of statutory issues that would have to be figured out in order to do digital disease surveillance. The states would have to probably enact some statutes. If the federal government wanted to do it, Congress would have to get involved. There might be some limits under the Constitution of the extent to which Congress could mandate this or that app or this or that technique. But putting all that aside, the most fundamental legal barrier would be the Fourth Amendment of the Constitution. So the Fourth Amendment to the Constitution does two things. The first thing it does is it prohibits unreasonable searches and seizures by the government. That's the first half of the clause, of the amendment rather. And the second half of the amendment states that if the government wants to get a warrant from a judge, permission to, let's say, search someone's home or person or automobile or digital device, they need to get a warrant from a judge. And a warrant in particular has a couple of requirements. The government has to establish probable cause, that the evidence of what they're looking for is where they're looking for. They have to specify particularly, that is in detail, what it is they're looking for. And there are a number of requirements that courts have come up with. So that's what the Fourth Amendment does. It prohibits unreasonable searches and seizures, and it says, government, if you want to get a warrant, you have to satisfy these requirements. So one question, this is a question at the heart of Fourth Amendment law, is what's the relationship between these two parts of the amendment? There are essentially two ways that courts have dealt with this problem, or two ways that courts have answered this question. One way, and this applies to day-to-day policing, what we think of when we watch, Law and Order or your average cop show, and the police go and they search someone's house. In that kind of day-to-day policing environment, the courts have said that what makes a search reasonable is, with a few small exceptions, but what generally makes a search reasonable is that the police get a warrant, right? They establish probable cause to a judge, they say with particularity what it is they're looking for, et cetera, et cetera. Now, under this kind of regime, under a regime in which the police have to get a warrant or the government has to get a warrant generally, digital disease surveillance would be impossible. Because think of what digital disease surveillance requires. In order to be effective, you have to surveil potentially millions of people simultaneously. And you have no reason to think that any particular one of them is infected. You certainly don't have probable cause to think that any particular one of those people is infected. In fact, you're pretty sure, statistically speaking, that the majority of the people you're surveilling are not themselves infected. So under the warrant, to put it another way, if warrants were required for digital disease surveillance would be impossible under the Fourth Amendment. Now, the Fourth Amendment has a different approach to what makes searches reasonable. And what courts have said is that when we're not dealing with traditional day-to-day policing, but when we're dealing with, and here the courts have used the term special needs, when we're dealing with investigatory systems that are designed not for traditional law enforcement purposes, the government doesn't need to get a warrant in order to make what it's doing reasonable. So the prime example of this is searches at airports. So back when we were all able to go to the airport and fly on planes, we'd all have to go through a fairly invasive search in order to get on an airplane. And that search, of course, is the metal detector. Right. Now, that search is warrantless and is without probable cause. Right? TSA knows that the vast majority of people that it is searching, and some of those searches can be quite invasive, but the vast majority of those people that are flying and going through this metal detector don't have any weapons on them, are not committed any crime. But what makes this search regime constitutional under the Fourth Amendment is that the goal is not primarily to fight crime. The goal is to secure airline safety. Right? The goal is to secure airline safety. And so what the courts have said is, because this program is designed for special purposes, not traditional law enforcement, the way we're going to figure out whether it's reasonable is not the way we usually do, which is to ask if the government got a warrant, but instead just to ask, is this reasonable? In other words, to balance the government interest in the search that it is performing against the privacy harm that that search is inflicting on individuals. And the courts have concluded, for example, in the case of TSA screening at airports, that that balance is satisfied and that the benefits the government gets in terms of safety outweighs the risks to privacy. So a digital disease surveillance system would have to be justified under that standard. And here, a lot just depends on the details. And so it becomes difficult to make a lot of predictions because when the courts apply this reasonable balancing analysis, they really focus on the details of a specific program. And there are a million different ways you could do digital disease surveillance. So a lot depends on the particular program, a lot depends on how intrusive it is, a lot depends on how useful it is to the government. But I do think that, and we can, I'm sure, talk about this later in the conversation, that with sufficient safeguards in place, one could design a fairly comprehensive digital disease surveillance program that is, on the one hand, quite effective in the public health goals of stopping infectious disease, but on the other hand, is sufficiently respectful of privacy and civil liberties that it would be constitutional under the Fourth Amendment. But again, just to emphasize, a lot depends on the details.
Okay, thank you, Alan. And my next question will be to Ron Thompson. We just heard that digital surveillance is important to fight infectious diseases. However, the technology is in its development stages. 2 months ago, NASA was the first government agency which implemented digital contact tracing agency-wide. This app resulted from a collaborated effort and data sharing process with involvement of health authorities, local and state governments in places where NASA officers are located, agency employees, and probably many more. Could you please tell us how this app was developed? How is it used? How data received is shared across the government? Were there any legal concerns in the development of this tool? And if any, how were they resolved? And also, while our speakers are presenting, I am encouraging the audience to submit their questions through chat, and we will ask these questions to our presenters.
Thank you, Peter. Yeah, thank you, Peter and Jane. Thanks for having me out today to talk to you about the NASA story. So I would just like to start out that privacy of our employees' information is our utmost concern. You know, I've worked in other federal agencies like the Census Bureau, and the privacy of data when I worked there was covered under Title 13 of the U.S. Code. So the importance of what our solution that I'm going to talk to you about and telling our story is our utmost importance. So early in the pandemic, around the April timeframe, we realized the severity of the pandemic at the time, and NASA is comprised of 10 geographic centers throughout the nation, and we've had different views of the state of the pandemic at the time. We were measuring things not consistently. Hospital data was coming in for capability for beds at the time, and we were just chasing and reacting as many organizations were. So around that time frame, we also were talking to state and local governments by chance on how the state and local folks were actually monitoring and tracking cases within different areas. So we chose a platform to develop what our doctors at each of these centers were doing manually through spreadsheets. So we took a look at how they were doing that, how they were collecting the data, and working with, again, the state and local entities of each of our geographic areas, and then developed a solution that was really about that time frame, really pretty much in place for a lot of these local government entities. So we took what was already developed and basically refined it to NASA needs very quickly. And with about 2 months time, we're able to automate, put in an automated system that showed us holistically a view of our agency. And at that time also, we were working with the Federal Chief Data Officers Council to make sure that we were leveraging CDC data, HHS data as much as we could to share definitions of terms. At the time, this was changing very widely. How we were actually measuring things. So that consistent data sharing and using that data that was collected for other purposes and bringing it into that holistic view of what we were seeing was really, really utmost important. And that interface is actually, that data is being shared across a number of agencies. So that was sort of early in the pandemic, and then we made a determination when to close. So we had a NASA definition of when to close as well. So that took us to about midsummer, and we saw the cases start to decrease at that time, and realized that we needed to prepare for when the vaccine was available. So we started since then actually using when our NASA population will be inoculated once the vaccine becomes available. So we're actually not only tracking the local awareness of hospital data across, using our internal definitions, using the consistent government definitions, and then also looking at how we're going to inoculate our people and protect our people as well. I will say that the contact tracing for our employees is totally optional. So this isn't a mandatory thing. So they can opt out, opt in, but it is being widely used consistently across our enterprise right now. So it's a really good example, I think, of really leveraging a community, really a federated community, sharing data among federal agencies and coming together consistently for a view for a specific need.
Thank you. And my next question is to Dr. Gesley. Jenny, what other countries are doing in the area of digital contact tracing? How common across the globe is the approach to use data in digital applications such as contact tracing apps to fight the coronavirus pandemic? How the efforts to monitor activities of the citizens correspond with the needs to protect their basic rights? And if an American will go abroad, what should he or she expect? Are the rights of the traveling Americans and privacy protected when they are in foreign country?
Well, thank you, Peter, for these questions, and thank you for having me today. I would also like to thank my co-panelists for their very interesting presentations, and I hope we can talk a little bit more about it later on. So, like you said, Peter, contact tracing is not a new tool. Many of contact tracing has been around for decades, but what's new is that a lot of governments these days are using digital tools to perform contact tracing. And the reason is that contact tracing just requires a lot of manpower, and digital tools just help make it more efficient, and they help to cut down on this manpower. And a lot of the digital tools were already used in 2014 to fight the Ebola crisis, but really now with COVID-19, it has become very prevalent. So governments are using a range of digital tools to fight COVID-19. Some are just for general advice about the disease, or some are just symptom checkers, but a lot of them are what we're talking about today, the contact tracing and warning apps. So more and more governments are adopting these apps. They're releasing these apps. So I would just like to start out with a few numbers. And I would just like to say this list is obviously not complete. I would just like to mention a few. So the first contact tracing app, to my knowledge at least, was the one released in Singapore in March of 2020, the Trace Together app. And then Australia was also among the first countries to release a contact tracing app in April 26th. On April 26th, and then Iceland, I think, also released the app already on April 1st. In the European Union, 18 out of the 26 member states have contact tracing apps. 4 are in the process of developing one, and only 4 have said that they will not release one. And those are Romania, Bulgaria, Luxembourg, and Sweden. And Sweden has a different approach anyway than most other countries. And reportedly, the app in Germany and the app in Ireland have the highest adoption rates. So the app in Germany has 23.5 million downloads so far. The app in Ireland, 1.65 million. Then in the UK, there are separate apps for England and Wales, Scotland, Ireland. Then some of the EFTA countries, Switzerland, Iceland, and Norway each have an app. Although I have to say that the app in Norway actually was stopped by the Data Protection Authority, and they're planning on relaunching it on December 21st. But I will talk about that in a little bit, the reason about that. And then other countries have apps as well. So China has the health code apps and the travel history cards. Taiwan has the so-called digital fence. Russia, Israel, India, they all have apps. And apparently, the Indian app is the world's fastest growing contact tracing app. It was reported that it had been downloaded over 100 million times after 41 days after its launch. So it's quite a lot. So this is really just a few that I wanted to mention. There are a lot of them out there. The problem is, though, that these apps are only effective if there is a high coverage and high utilization rate among the population. So what is preventing from people from using such an app, or what would encourage them to download such an app and use it? So people are concerned about data security, they're concerned about privacy, they're concerned about data protection. And the issue is that privacy and data protection laws, they vary widely among the countries around the world. So there's always different requirements. How can you balance safeguarding public health with protecting privacy and personal data? So some countries have very strict rules, whereas others have either lower standards, or there are some countries that have no laws protecting privacy and personal data. Egypt, for example, did not have a law to protect personal data until October 17th of this year. So most of you have probably heard of the data protection framework in the European Union. Privacy and data protection in the European Union are fundamental rights. They're protected in the EU Charter and the Treaty on the Functioning of the European Union. So we know they're protected in the General Data Protection Regulation, the GDPR, and then there's also the e-privacy directive for the electronic communication sector. So the GDPR, the standards, they are very high. In particular with regards to the lawful processing of personal data, and then in general, the processing of sensitive data is normally prohibited under the GDPR. But then we have exceptions for example, for safeguarding public health. So this is used here in the current pandemic to fight the spread of the coronavirus, this exception. I would also like to point out that the GDPR, so the standards are also applicable in the UK, which is currently in the transition period from Brexit, and then also in the countries of the European Economic Area, which are Norway, Iceland, and Liechtenstein. So other countries have, lower standards, like I said, or then there were some countries where, for example, the data protection standards were lowered to fight that pandemic. Russia, for example, in the city of Moscow, the mayor issued a decree in October of 2020, which orders employers to submit certain information about their employees to the city government about the teleworkers, because one of the measures is people should work from home and not go into the office to minimize contacts. So they had to submit people's cell phone numbers, then license plate numbers, and then also numbers of electronic cards that are used to pay for public transportation and for other social services. And the federal ministry in Russia said, though, even though normally data protection law is federal law, this is legal in this case to fight the pandemic. So what are some of the issues that are discussed with regard to contact tracing apps around the world? We don't really have so much time, unfortunately, but I would just like to briefly mention a few. So first of all, are these apps voluntary or are they mandatory? Then do they use Bluetooth? Do they use GPS? Or maybe both of them? Then another issue is how transparent is the data collection? Is there a specific legal basis for this app? And then last but not least, is the data storage centralized or is it decentralized? So with regard to the voluntariness of the apps in the European Union, for example, the European Union recommends voluntary apps because they say mandatory apps are too intrusive. The European Data Protection Board has also issued the same recommendation, and so far all the apps that have been adopted in the European Union are voluntary apps. But one of the problems with voluntary apps is that download rates a lot of times remain very low, which limits the effectiveness of the app, as I mentioned before. So download rates are generally higher if people know that their privacy and that personal data is protected. Well, but on the other hand, stronger privacy protections sometimes limit the effectiveness of tracing the spread of the virus. So it's really a difficult decision for governments to make. So some of the governments around the world have made their apps mandatory. So just a few examples. In Vietnam, for example, foreign visitors on a short-term visa, they're required to install the social monitor, the contact tracing app while they're in the country and satisfy other requirements. And if they don't do that, then they have to quarantine. India, for example, the app was voluntary at the beginning in April when it was launched, but then in May it became mandatory for public and private sector employees. But that requirement then was eased again after privacy and digital rights groups complained about this. In Russia, everyone who has been in contact with an infected person has to install the social monitoring app or face a fine. The next issue I would just like to briefly mention is the issue of transparency or a specific legal basis. In both of these measures, they add to the public acceptance of an app because people know how the data is going to be used and if there are any security risks. So in the European Union, for example, the source code and the technical specifications for 2/3 of the apps were publicly released on platforms like github.com. So everyone can go there, they can see, okay, this is, it's open source, and we can see what the source code is, and they can also help to improve the app and find security flaws. And this has actually been used quite a lot and has improved some of the apps. For example, Switzerland, Norway, and Italy, they have adopted specific legislation just for the operation of the app. So that also helps. People know exactly what data is collected, how it's going to be used, what oversight mechanisms are there, what's the retention period, and so on. Australia, for example, they first launched the app, but then later on amended their privacy law to add a new section on the app. Then location tracking is another contentious issue. The European Data Protection Board, for example, has said that it violates the principle of data minimization because it's not actually needed for contact tracing. And we can see, a lot of the apps have used Bluetooth and proximity tracing. I mentioned that the Norwegian app, for example, was stopped by the Data Protection Authority, and that was because they used GPS and Bluetooth to track the user. So in July, the Data Protection Authority there said that this is not proportional, and the government had to stop collecting patient data with this app. So it stated that there was, first of all, low community spread in Norway, then the central collection of data was invasive, and they said the low number of users, it was only like 14% of the population, that prevented effective tracing. So that's why they're hoping now to design it in a proportional way, and hoping to relaunch it on December 21st. So we'll see if that will succeed. And then just another short, briefly mention of the storage of data. Most apps in the European Union, at least, or in Europe in general, use decentralized storage of data. There's only a few that use centralized storage of data. For example, the apps in France, in Hungary, Norway, and Iceland. And but the discussion which one is better for privacy and data protection purposes is a difficult one, and has also delayed the launch of the apps in several countries. For example, in Germany and the UK. The UK, for example, they were actually originally planning on doing centralized storage, and then they switched to a decentralized model. So those were really just a few points I wanted to make. And I hope that we will be able to discuss some of them in more detail later on. Thank you.
Thank you, Jenny. And let me start with some follow-up questions, and probably the first question will go to our first presenter, Professor Rozenshtein. You said that balance between civil liberties and surveillance will depend on safeguards which you will create, establish later. But what kind of safeguards do you foresee could be placed? What role in this process can be played by the courts? How they can enhance the privacy protection standards? And also, what will be the development standards for reviewing such cases? And my questions correspond and coincide with the question we received from the audience. People are asking if hypothetically Fourth Amendment suits brought against government can be brought under Bivens. Could you please answer?
Sure. So there's no one answer to the question of how the courts could, for what sort of safeguards could be created to make sure that these programs are valid under the Constitution. I mean, a lot of this just comes down to designing programs that do their best to minimize the privacy harms at issue. So, for example, a digital disease surveillance program ideally would be very transparent. So everyone would know who is being surveilled, how they're being surveilled, when they're being surveilled. And the reason for this is that unlike with a law enforcement or national security surveillance program, where you need to keep things relatively secret because otherwise the targets of your surveillance will evade it, with something like a digital disease surveillance program, that's not really what you're worried about. So we can afford to be maximally transparent without sacrificing the effectiveness of the program. So that suggests that any program that wasn't quite transparent would be one that courts should look at with a lot of suspicion. Another aspect of a digital disease surveillance program that would be important to think about was how is that information shared? So one could imagine a variety of options. One could say, look, if any information shared under a disease surveillance program could be useful for law enforcement, let's just give it to law enforcement so they can also fight crime with that. I think that would make a lot of people and that would make a lot of courts very uncomfortable. If instead, as is the case with something like the census, the information collected under this program would be strictly locked down and could only be used for digital disease surveillance and could not be used for criminal law enforcement, again, that would be another sort of safeguard that would make it more likely that courts would uphold the program. Now, ultimately, after you've made all of your kind of optimizations, right, after you've designed a program that is maximally privacy protective given the public health needs of such a program, there's still going to be a trade-off. You still will ultimately sacrifice some privacy for public health. There's just no way around that. And at that point, the question becomes, what role should the courts have in deciding whether or not the trade-off that the government chooses is the right one? And here, my personal view is that courts should take a pretty hands-off approach. as long as the government has shown that it put a lot of thought into figuring out the appropriate trade-off. So, for example, if Congress passes a law mandating a certain kind of program, and they're pretty detailed about what that program does and how it's operated, and then the federal government implements that program and they consult with the public and they get comments from stakeholders and they incorporate that. The output of that process, to me, reflects, as close as we can in a society as diverse as ours, the democratic consensus of what is appropriate in terms of balancing privacy against, in this case, let's say, public health. And under a regime like that, I think the courts should be quite deferential to that determination, as long as they've convinced themselves that the process by which the government came to that determination was democratic and representative. Now, none of this is guaranteed to happen, right? The government could roll out a really poorly designed program, a program that doesn't have these democratic safeguards in place, a program that's not effectively designed. And I think at that point, the courts would be well within their rights to strike a program down under the Fourth Amendment. Now, how they would do it, the question asks about Bivens, and Bivens is this 1971 Supreme Court case in which the court said that although the Constitution, neither the Constitution nor federal law explicitly provide for a damages remedy against the federal government for a Fourth Amendment violation, it will still allow it. Here, I think that the main relief that a plaintiff would be looking for in challenging a program like this would not be monetary damages, it would be injunctive relief. It'd be an order from the courts to the government telling them to modify the program or just to stop the program entirely. And that I don't believe, and I wanted to check, this is getting into a very technical area of law, I'd want to check to make absolutely sure, but I'm pretty confident that that would not require going through the Bivens remedy, that if you're just asking for injunctive relief, that's sort of always available. Now, whether you win or not on that, it's obviously a different question, but that you can always walk into court and at least ask for that if you have a strong claim on the merits.
Thank you. And for Mr. Thompson, my question is more technical and probably more practical. Many states and counties are experimenting with contact tracing apps. How is NASA's app compatible with other similar applications? Does it allow interoperability? Does it keep monitoring when an employee travels from one office to another across the country? Does it monitor meeting quarantine requirements if an employee is exposed or is asked to quarantine himself? And also, privacy advocates insist on pseudonymization of data collected. How does it work with an agency app?
Okay, thanks, Peter. And I see some other questions in the chat where what is NASA? And just to be clear, I am from NASA. I cited the census example for privacy given where I worked before, but NASA is National Aeronautics and Space Administration. So just to be clear, I think there were some questions in the chatter. So the way we are choosing to deploy contact tracing for our agency, it is holistic across the geographic areas where our people work. It's across the United States, and it is a consistent instantiation that is used across our centers. So if we have one employee travel from one center to another, it is in that central system. Our data is protected, and privacy is the utmost importance of these data that we have. And in fact, when someone discloses they are tested positive, and this is after a valid test has been done, they are test positive. They're basically asked a series of questions. When were you detected positive? When was a positive case? Who did you come in contact? Where did you go? So it's a very consistent approach with what we're doing across the agency, and it is consistent approach with how other local entities are doing this work as well. And then the data is not shared beyond beyond our use of it. So it isn't shared outside, although the data we're ingesting for like bed availability, the sliding averages of cases throughout a geographic area, that's data ingested in, but we do not send any data outside of our agency once it's collected on our employees, and it is completely protected. So that's our instantiation of it, Peter. Want to make sure, I think there were like 3 or 4 parts to that. Want to make sure I've touched on everything. Is there anything that we need to expound upon?
Yes, you answered, I think, the question about stigmatization, and let's see if other questions will come about technicalities of this.
Okay, thank you, Peter.
Thank you. And Jenny, according to your report, it looks like almost each country in Europe introduced its own contact tracing app. Are the different tracing apps interoperable, or do a person needs one when he travels from one country to another?
Yeah, thank you, Peter, for this question. So, well, let's say they're in the process of making them interoperable. Because especially in the summer when numbers were down and people were traveling again for, to other European Union countries, they realized that people don't want to download a new app every time they go to a new country, and they shouldn't be, and especially because when it's a new national app, you already know how your data is going to be used, and in a new app, there's always other problems. So they were working on making it interoperable. So in May 2020, there were general interoperability guidelines that were adopted. In June, the EU member states then agreed on technical specifications, and they also published guidelines that set out the basic interoperability elements. And then just recently, in October 2020, that interoperability gateway went live, and currently 9 out of the 18 apps are linked. So those are the apps in Croatia, Denmark, Germany, Latvia, Ireland, Italy, Spain, Netherlands, and Poland. So these are currently the ones that are linked and that can talk to each other, as they say. So you don't need to download a new app when you go to any of these countries. And they're hoping to add more later on. So this is the goal. And the problem only is, though, that currently this interoperability gateway, it only works for apps that use a decentralized storage solution based on the Google Apple API. So any other country that has centralized storage of data, it won't work for these apps. So, for example, for France and for Hungary, they can't participate in this. So there you still need to download a new app if you go to one of those countries. And then even though, for example, the apps in the UK, they use decentralized storage, and the one in Switzerland uses decentralized storage, those are unfortunately not interoperable with the European Union ones. And that was actually, I think, also one of the questions in the chat. Are there any international agreements to share health data between countries? So because, there's no agreement with the UK or Switzerland to share health data, those apps will not become interoperable because you first need an agreement to share health data, and those are not in place right now because Brexit agreement hasn't been negotiated yet, and Switzerland, there's no agreement to that regard, although they're hoping maybe to do that at some point because it's so close and people do travel a lot, and they're also part of the Schengen area. Another thing, with regard to that question in the chat, international agreements. So the EU countries also, with regard to that interoperability gateway, so there is a decision from the European Union on combating serious threats, cross-border threats to health. And that decision lays down certain rules about epidemiological surveillance and monitoring. And then there's an early warning response system, and there's also responsive measures. So, and this decision also has certain requirements for data sharing for these purposes. So, and it especially talks about contract tracing in this regard. So, and then again, it just says this all data processing for this regard has to be in compliance with European Union data protection rules. And the countries have to provide specific safeguards for the exchange of this sensitive health data. And the European Commission has then also issued guidance and an indicative list of what personal data should be shared using that early warning response system for the purpose of contract tracing.
Thank you. You already answered one of the questions from the chat about international arrangements about data sharing. And there is another question for you, Jamie. It is about Norway example. What are the particular reasons for privacy concerns raised there? Could you please elaborate on it?
Yeah, sure. The Data Protection Authority there, so it was a longer process where they also then let the agency respond, the health authority. But what they basically said is, so Norway doesn't really have, they said there's a low community spread in Norway. The central collection of the data is invasive, and because it was really, so at the beginning, the app was apparently very popular, but then the number of users dropped, and it dropped to only 14% of the users. And they said that actually prevented effective tracing. So they said all these measures together make the response, unproportional. Because with location tracking, location tracking is normally more invasive than just proximity tracing. Because with location data, you can also, make, for example, certain patterns depending on where you are, you can, learn a lot more about people than just, whether in contact with an infected person. So it's more invasive from a privacy perspective. And that's basically those three reasons is why the Data Protection Authority said that in this, instance, it's not proportional, and they need to redesign their app. And then I see, if I'm already talking, I see another question in the chat, if there's any list of the European Union countries that are interoperable. And there is such a list. So the European Union has a list of all the apps, of all the countries that have apps. It's very nice list actually, and then it says if they are interoperable with each other or if they're planning on becoming interoperable soon. So if there's the potential, and you can look that up on the European Union website. I think if you just Google it, contact tracing apps in the European Union, you're probably able to find it. But I can also find this link somewhere. I have it somewhere in my notes.
And there is another question I see about regulations within the African Union. I would suggest maybe this person will contact us and submit this question using our Ask a Librarian system coming through to our website law.gov, and our specialist who covers African countries will respond and answer. And also I have a question for all of you, and this question was asked by several participants of our event today. How, in general, these applications are effective and accurate? Who will answer it?
I can start. I can give my thoughts. So I think, again, it depends enormously on how they're designed and how they fit into the larger public health system. So let me start with the first. So again, contact tracing apps and digital disease surveillance as a whole comes in a lot of different options, and you can go from, on the one hand, systems that are that do maximal amount of surveillance to get the max amount of information and they might have the best public health impact if they're used correctly, but they will also be maximally privacy intrusive. And then on the other hand, you can have systems that are incredibly careful about preserving privacy, but because of that, they're not necessarily that helpful. One example, I think, of the latter is the Google-Apple API, upon which most of the current contact tracing apps are built. So Google and Apple control the Android and iOS operating systems respectively, and in order to gain access to the whether it's Bluetooth features or GPS features on a phone, you have to kind of go through Apple and Google and get permission to do that. And so near the beginning of the pandemic, Apple and Google decided to work together to create this API, and the technical details don't matter so much, but you can think of it as just a kind of a set of permissions for application developers to design their own contact tracing apps that would work on Apple and Google phones. Now, Apple and Google made some choices in that process. They decided that the right balance to strike was that the Bluetooth systems would be available for contact tracing, but that the GPS system would not be available for contact tracing. So for all apps that are built on the Apple-Google system, you can do proximity tracing. So because of the Bluetooth feature, if one phone gets next to another phone, those phones can talk to each other, but that will not record where in space that occurred, because the GPS information cannot be included. Now, Apple and Google made that decision for a variety of reasons. Presumably, they thought that that was the appropriate balance to be struck. And those are the contact tracing apps that we now have. They are fairly privacy protective, which is a good thing. They're also not necessarily that useful, unfortunately, which is not necessarily a good thing. Again, it all depends on what your personal values are. And then finally, even once you have a contact tracing app, it might be the best contact tracing app in the world. You might have the best digital disease surveillance, but if you're not at the same time pairing that with effective testing, effective treatment, support for people that need to be in quarantine, good public communication, good analog, traditional contact tracing, it doesn't really matter, right? So today, for example, right now, given the community spread level in the United States, we could have the best contact tracing apps possible, and right now it wouldn't be all that helpful. So the question is not using digital contact tracing as a replacement for other public health tools. It's using them as one of the tools in our toolkit, and the other tools have to be good too, right? We're not going to get our way out of this or future pandemics just by having really sophisticated surveillance.
So I'd just like to add, Alan, that was perfect. The way you described that, I don't think any tool is going to be 100% accurate. It's the human factor of what goes into the tool and how it's used. So very eloquent response there. I will say from our example, it is we're using it as a reactionary way to see where infected individuals were in our ecosystem. Okay, so it's a purpose-built after testing was done, after positive confirmation is done on a test. Where did you go? So we're actually linking into our authoritative data sources to see what meetings were held. If somebody was in one of our locations, one of our centers in person, who were they meeting with? So all of this is the way our implementation is in NASA, it's a reactionary stance. It isn't a proactive proximity capability, although technically we can do many things technically, but I think as Alan described, it is where we choose to draw that line is really up to us societally. What is our culture? What are we comfortable with? And I'm just giving you our NASA's example, and it's just like state and local governments. When you test positive for a local in any of these local areas, they actually call you and ask you a lot of the same questions for consistency, but they're basically wanting to track who you came in contact with, so they can then follow up and make sure others know about it and they're tested. So we're using it at a very reactionary implementation.
Thank you so much. And I think we have, Jenny, sorry.
Oh, I just wanted to add that I agree with both of the other speakers. And I mean, the WHO has also said that it should only be used, contact tracing should only be used as an additional tool. We really also need other public health measures to contain the spread of this virus. So yeah, and how effective voluntary apps are, we really can't say yet, the digital apps, because they're also new and they haven't been used as much before. So there's really no data yet, and we also don't know. Sometimes people, even though they have a positive result, they might not enter it if it's a voluntary app. So there's really no good way of telling how effective or how accurate they are at the moment.
Okay, and I think we have time for one last question, and this question is a matter of concern for several of our attendees. People are asking, should we keep these apps voluntary, optional, or we need to make them mandatory for their success? What is your opinion?
So I generally default to making things voluntary if possible. It just removes a huge amount of complication, of legal difficulties, of political difficulties. I think the problem, though, is that at least from the experience of other countries, voluntary apps just do not get enough of a pickup. They do not get enough participation to be particularly effective. And so it may be, I think you should start with voluntary, but I think you have to be always prepared. You always have to design your programs, if you're serious about them, for the possibility that at some point they'll have to become mandatory. Because I think experience shows that voluntary participation won't necessarily get you there.
Yes, I mean, as we've seen, when I look at all the apps that are around that are voluntary, a lot of them, like you said, have a low download rate, so they're not as effective. On the other hand, I mean, the German app, for example, and the Irish app are both voluntary, and there is a pretty high adoption rate. So I guess it also really depends on how they're designed, how transparent the process is, and if people are, assured that their data is protected. So that means voluntary apps can be, but yes, in some cases, maybe if the adoption rate is so low, you might have to make them mandatory. But then, you have to put in certain safeguards still. So it's really a difficult balance. But I agree that probably you should first start out with voluntary apps.
Okay, thank you. And I think we just started this discussion. We raised questions. It looks like we have more questions than answers today. But it was probably the purpose of our event, and to start to find answers for these difficult questions. And I would like to thank all our panelists. I would like to thank all our audience and congratulate again with the Human Rights Day 2020. Thank you.
Thank you, Peter.
Thank you.
Thanks for having me.
Thank you all so much for joining us. We really appreciate it. Thank you for this interesting discussion on contact tracing and the right of privacy. Just want to remind everyone that you can visit our site at law.gov and look at our Legal Research Institute page for information on our upcoming webinars on domestic and foreign law. And again, thank you so much for coming today.